Morning, everybody. It's Monday morning, a little bit before 6 a.m. I'm getting up. I'm going to get my daughter up to go to school here in a little bit. And this will be lesson number 3 on my series on evidence and the Kentucky evidence rules. I was debating whether or not to do this one or authenticity, because they are somewhat interconnected, but I think I'll do this one first. So it's called the best evidence rule. It's contained in Evidence Rule 1000. And basically what it means is when you introduce something, you have to introduce essentially the best evidence. So what would be the original? I'll give you an example. If there is a video of somebody committing a crime and a police officer testifies and starts describing that video without introducing the video, the testimony of the police officer watching that video, and I've had this come up several times, that is not the best evidence. The best evidence is the actual video, okay? So that's what you're gonna introduce. Similarly, if you and I have a contract, me talking about the contract is not the best evidence. The actual contract is the best evidence. So you would, introduce the contract, or in some cases, a copy of the contract, as long as it's, can be authenticated. So that is really simply what the best evidence rule is. Now, you can get into issues because there are some exceptions to the best evidence rule. One would be if the original is lost. Another would be if the other party has it and just doesn't provide it. Then you can deal with that. Now, if they're not going to provide it, then you're more going to be dealing with things that are, that are going to be confidential, or something that they cannot legally provide, like NDAs or something like that's confidential. But in some cases, you need to be able to, produce it to prove your case, whether or not they're able to provide it or not. So those are some of the exceptions to the best evidence rule. But generally speaking, you're supposed to introduce what you're talking about. So especially if it's a document, you introduce the document. You don't introduce testimony about the document. So that is essentially the best evidence rule. It doesn't come up terribly too often because people, usually if you got a document, you want to introduce it. But I've seen cases, and I get this, we'll all have a police officer recording, the recording, like they'll go see a security camera, and then they'll record on their cell phone, the record. Well, the best evidence is the actual recording, not you recording, especially when you're making comments and there's people talking, and that's why you want to introduce the actual recording. So for my fellow police officers out there, please just get the actual recording from the store. Don't record it on your cell phone, because that's not the best evidence, and that'll run you into some issues, especially if there's a conviction on appeal. So I mean, that's it. It's a very simple rule, but it comes up where you kind of don't think it'll come up, and when it does, it can mess up a case. And I say this because when I was one of the, I won't say first cases I tried, but it was it was, I think, 2009. There was an issue of the best evidence rule, and there was a conviction, and the case went to the Supreme Court, and the Kentucky Supreme Court said, hey, look, no, you gotta introduce the actual recording. You can't introduce somebody talking about the recording. Now, they did say, well, we'll find it what's called harmless error, but I did object to it, and I did explain the objection. So it's not used terribly too much because common sense oftentimes says we use the actual document, but you do get issues where sometimes people want to talk about it as opposed to introducing the actual document and or recording or whatever it is. So that's the best evidence rule. It's pretty simple. It's the best I can do to explain it. So if y'all have any questions, let me know. This is lesson number 3. Next, I'm going to do authentication. And there are many people that do not understand the authentication rule and the requirements, and there's some confusion about what is actually required. And so I'm going to deal with that next. And then after that, I'll probably do hearsay. And hearsay is, I'm going to have to break that down because there are like 20-something rules regarding hearsay, and there's non-hearsay. And so that's a long topic. I mean, when you take evidence, you spend half of evidence just on the hearsay rules because it's really common, and a lot of times it's not what people think it is. So I will go into that. That may be one of my last things I do. I'll try to do, a couple other ones, but authentication I'm going to do next because I think it's important. So hope you all have a good day. If you have any questions, let me know. Comment down below. You know how to get a hold of me. Take care.